But I'm often asked, people wonder, are these hearings turning into a circus? And I want to defend circuses. Circuses are entertaining, and you can take your children to them. This hearing is neither entertaining nor appropriate for young people. Now, some of my colleagues who I respect greatly are trying to make a point. I don't know what that point is. But I do know this: if you want to be president, which I can understand that, it's hard. And what you do will be the example others will follow. Back to the subject matter. Let's talk a little bit about the law regarding the president. Clinton v. Jones tells us, see if I'm correct, that you can be president of the United States, you can still be sued for conduct before you were president, and when you invoke executive privilege, the court has said, no, wait a minute, you have to show up at a deposition because it happened before you were president. Is that correct?
Yeah, in a civil suit was the Clinton versus Jones case involving allegations that, or a suit that had involved activity before President Clinton became president.
Okay. So it's pretty well understood through Supreme Court precedent that if you're the president of the United States and you engaged in conduct that allowed you to be sued before you got to be president, you can't avoid your day in court and on the civil side. Okay, now whether or not a president can be indicted while in office has been a discussion that's gone on for a very long time. Is that true in the legal world?
That's correct. The Department of Justice for the last 45 years has taken the consistent position through Republican and Democratic administrations that a sitting president may not be indicted while in office. The most thorough opinion on that is written by Randy Moss, who was head of President Clinton's Office of Legal Counsel in 2000. He's now a district judge appointed by President Obama on the district court in D.C.
I think you have written on this topic as well, haven't you?
I've not written on the constitutionality.
You're talking about whether or not it would be wise to do this.
I've made my thoughts known for Congress to examine because in the wake of September 11th, I thought one of the things Congress could look at is how to make the presidency more effective.
I just want my Democratic colleagues to remind you that when President Clinton was being investigated, you took the position that he's not above the law, but in terms of indicting a sitting president, it would be better for the country to wait. And the person who echoed that the most, or at least effectively, I thought, from his point of view, was Joe Biden. So there's nothing new here, folks. When it's a Democratic president, they adopt the positions that they're arguing against now, but that's nothing new in politics. I'm sure we do the same thing. So this man, Judge Kavanaugh, is not doing anything wrong by talking about this issue the way he talks about it. What we're doing wrong is blending concepts to justify a vote that's going to be inevitable. You don't have to play these games to vote no. Just say you don't agree with his philosophy. You don't think he's qualified. But the thing that I hate the most is to take concepts and turn them around upside down to make people believe there's something wrong with you. There's nothing wrong with you. The fault lies on our side. Most Americans, after this hearing, will have a dimmer view of the Senate, rightly so. So it's okay to vote no, but it's not okay to take legal concepts and flip them upside down and act like we're doing something wrong on the Republican side when you had the exact same position when it was your turn. Roe v. Wade. You've heard of that case, right?
I have, Senator.
Okay. Now, there are a lot of people like it, a lot of people don't. It's an emotional debate in the country. Is there anything in the Constitution about a right to abortion? Is anything written in the document?
Senator, the Supreme Court has recognized the right to abortion since the 1973 Roe v. Wade case and has reaffirmed it many times.
But my question is, did they find a phrase in the Constitution that said that the state cannot interfere with a woman's right to choose until medical viability occurs? Is that in the Constitution?
The Supreme Court applying the
It's
liberty.
pretty simple. No, it's not, Senator Graham.
Well, I want to
But those words.
I want to be very careful because this is a topic on which.
No, if you'll just follow me, I'll let you talk. But the point is, will you tell me, yes or no, is there anything in the document itself talking about limiting the state's ability to protect the unborn before viability? Is there any phrase in the Constitution about abortion?
The Supreme Court has found it under the Liberty Clause, but you're right that specifically.
Is there anything in the Liberty Clause talking about abortion?
The Liberty Clause refers to liberty.
Okay,
but not,
well,
does not
last
have
time I
specific-
checked, liberty
Yeah.
didn't equate to abortion. The Supreme Court said it did, but here's the point. What are the limits on this concept? You had 5, 6, 7, 8, or 9 judges. What are the limits on the ability of the court to find a penumbra of rights that apply to a particular situation? What are the checks and balances of people in your business, if you can find 5 people who agree with you, to confer a right, whether the public likes it or not, based on this concept of a penumbra of rights? What are the outer limits to this?
The Supreme Court in the Glucksberg case, which is in the late 90s, Justice Kagan talked about this at her hearing, is the test that the Supreme Court uses to find unenumerated rights under the Liberty Clause of the Due Process Clause of the 14th Amendment, and that refers to rights rooted in the history and tradition of the country, so as to prevent.
So let me ask you this. Is there any right rooted in the history and traditions of the country where legislative bodies could not intercede on behalf of the unborn before medical viability? Is that part of our history?
The Supreme Court precedent has recognized the right to abortion. I'm sorry.
But I'm just saying, what part of the history of I don't think our founding fathers, people mentioned our founding fathers, I don't remember that being part of American history. So how did the court determine that it was?
The court applied the precedent that existed and found in 1973 that under the Liberty Clause.
Yeah, but before 1970, I mean, when you talk about the history of the United States, the court has found that part of our history is for the legislative bodies not to have a say about protecting the unborn until medical viability. I haven't, whether you agree with it or not, I don't think that's part of our history. So fill in the blank. What are the limits of people in your business applying that concept to almost anything that you think to be liberty?
And that is the concern that some have expressed about the concept of unenumerated rights.
Well, here's the concern I have, that you got one word that has opened up the ability for 5 people to tell everybody elected in the country, you can't go there. That this is an off limits for a democratic process. Whether you agree with Roe v. Wade or not, just think what could happen down the road if 5 people determine the word liberty means X. The only real check and balance is a constitutional amendment to change the ruling. Do you agree with that?
Senator, I'm not going to comment on potential constitutional amendments.
But, okay, how, if we pass a statute tomorrow in Congress saying that the Congress can regulate abortions before medical liability, wouldn't that fly in the face of Roe v. Wade?
So the Supreme Court has said that a woman has a constitutional right
Doesn't that trump a statute?
The Supreme Court
So
precedent.
all of us could vote. There's 5 people have said liberty means right to the state has no interest here, compelling interest before medical viability, that we could pass all the laws we want. It doesn't matter because they fall. The only way we can change that is a constitutional amendment process that requires 2/3 of the House, 2/3 of the Senate, 3/4 of the state. Is that a pretty correct legal analysis?
When the Supreme Court has issued a constitutional ruling,
Then you can only change it by constitutional amendment.
That's the
So here's the point. Whether you agree with Roe v. Wade or not, the reason some legal scholars object to this concept is breathtakingly unlimited. Whatever 5 people believe at any given time in history in terms of the word liberty, they can rewrite our history and come up with a new history. And I think the best way for democracies to make history is to have the courts interpret the Constitution, be a check and balance on us, but not take one word and create a concept that is breathtaking in terms of its application to restrict the legislative process. Now, whether you agree with me or not, I think there's a genuine debate. And you would agree with me if it was something you liked or you were supporting that got shut out, or you opposed you couldn't do. So I hope that one day the court will sit down and think long and hard about the path they've charted, and not just about abortion. Whether or not it's right for people in your business on any given day, based on any given case of controversy, to say that the word liberty, looking at the history of the country and the penumbra of rights, means X, and it shuts out all of us who have gone to the ballot box and gone through the test of being elected. All I ask is that you think about it. I want to ask you about something else to think about. You said you were in the White House on 9/11. Is that correct?
That is correct, Senator.
Did you believe America was under attack?
Yes. It was under attack.
Right. Do you believe that if the terrorists could strike any city in the world, and they had you get a one shot at the world, based on your time in the White House, do you believe they'd pick an American city probably over any other city?
Well, it certainly seemed that New York and Washington, D.C. were the 2 targets.
The only reason I mentioned that to my good friends, and they are, who believe that America's not part of the battlefield, it sure was on 9/11. The law. If an American citizen goes to Afghanistan and takes up the fight against our forces, and they're captured in Afghanistan, the current law is you can be held as an enemy combatant in spite of your citizenship. Is that correct? Is that the Hamdi decision?
That's what the Supreme Court said in the Hamdi decision with appropriate due process findings.
Absolutely, appropriate due process findings. Here's what I want people in your business to think about. Are you aware of the fact that the radical Islamic groups are trying to recruit Americans to their cause? That they're over the internet trying to get Americans to take up jihad?
Yes.
The likelihood of an American citizen joining their cause is real because it's happened in the past. The likelihood of it happening in the future, I think, is highly likely. If an American citizen attacking the embassy in Kabul can be held as an American citizen, here's the question. Can an American citizen collaborating with other terrorists who are not American citizens be held as an enemy combatant for attacking the Capitol? And if they can't, you're incentivizing the enemy to find an American citizen because they have a privilege that no other terrorist would have. So you said something was very compelling to me, that you apply the law and you have to understand how it affects people, right?
Yes, sir.
I hope you will understand that this war is not over, that the war is coming back to our shores. It's just a matter of time before they hit us again, because we have to be right all the time, and they have to be right one time. I hope we don't create a process where if you can come to America, you get a special deal. Makes it harder for us to deal with you and find out what you know. We treat you as a common criminal versus the warrior you've become. That's just my parting thought to you. And you'll decide the way you think is best for the country.